Let me start by thinking about our topic, human rights, and trying to understand where it came from historically. And that's a complicated question because it has all sorts of different sources. The first is the Reformation. After 2 centuries of wars of religion, eventually secular rulers realized that far from it being necessary for a nation's peace for everyone to follow the same version of Christianity, it would be better if citizens were given liberty to worship the Christian God in the way that they thought best. And that's really important because, as we'll see when I'm talking on Monday to the Politics and Society Network, the freedom of religion is the foundation for many of the other fundamental freedoms that we enjoy today. Freedom of association, freedom of speech, freedom of education, freedom to marry, and so on. The second source of human rights thinking is John Locke. It is difficult to overemphasize the importance of John Locke as a philosopher. His philosophy became the sort of unofficial guiding philosophy, both behind the constitutional settlement in England from the 17th century onwards, and also, and even to a greater extent, behind the ideas that led to the founding of the United States of America. And Locke is really important because, in contrast to theories that were alive in his day that claimed that the king was the absolute sovereign, Locke wanted to say, no, society exists on a very different basis. It exists on the basis that it is there to protect the natural rights that individuals have. And the most important of those natural rights is the right to property, which Locke thought of as being about both the property, the physical goods that people own, but also about the property that people have in their persons. So Locke gives us this idea of natural rights. When I'm being rude, I sometimes describe it as a human rights theory for rich white men. But that is what he does, and it is a turning point, a decisive break with the kind of old understanding, which wasn't actually that old, it was innovative, but these claims by centralized states that the sovereign controlled everything. Another key thinker in the development of human rights is a guy called Hugo Grotius. Now, Hugo Grotius, also writing in a context of bitter conflict, this time in continental Europe, wrote a book called The Law of War and Peace, which was designed to say that even when countries were at war with one another, there were certain rules that applied, certain ways that people ought to be treated. Now, like Locke, Grotius was coming from a Christian background. Grotius was probably a more orthodox Christian than Locke was. But at one key point in his argument, he says, even if there were no God, etiam si in Latin, even if there were no God, human beings would still be bound by this law. And that phrase has been seized on subsequently, probably contrary to Grotius's intentions, to create the idea that human rights and natural rights can float free from any belief in God. But human rights really come to the fore with the French Revolution. French Revolution with its Declaration of the Rights of Man, which comes complete with the slogan, ni Dieu ni maître, neither God nor master. Nobody can tell me what to do. And from this source flows into modern human rights theory, the idea of human rights as some kind of freestanding, self-supported system of beliefs and values. And somebody who's really important in the intellectual tradition that develops from the French Revolution is called Thomas Paine, and we will come back and have a little look about what he said a little later on. But that gets us through to the late 18th century. In the 19th century, the idea of human rights really goes into some sort of eclipse. It's taken over by the philosophy of utilitarianism, and other big sort of ideas, revolutionary ideas, communism and so on, are flowing through the system. So everything becomes about the best good for the community or a particular class. And the position of individuals begins to become a bit shaky within all of that. And in the 20th century, this idea that everything was really fundamentally about the state or about the class led to two different kinds of revolution, the fascist revolutions that culminate in Nazism in Germany, and the communist revolution, which culminates in Stalinism in the USSR. And what both those systems do is to oppress their people and commit all sorts of murderous acts. And it is coming out of the Second World War, when the horrors of the concentration camps and the extermination camps have been discovered by the Allies, and when news about the gulags and other things that are going on inside the USSR are beginning to emerge, that people look around for some sort of way of describing fundamental ways in which people deserve to be treated, and things that are fundamentally wrong, whether there is a written law against them in a particular country or not. And the idea of natural rights is kind of dusted off and used as the idea of human rights to create international standards by which governments will be held to account. But I think there's one thing more that we can see. I think from around the late 1960s, early 1970s, we see a different understanding of human rights beginning to push in, where more and more emphasis is placed on choice. So let me just go back and talk a little bit more about John Locke and Thomas Paine. And the reason I want to do that is because I think that they set up two very different routes for getting to human rights and ultimately for how we might think about them today. So for John Locke, natural rights are out of human nature. And for Locke, human nature includes human equality, and specifically equality between men and women. Now, one of the things that is striking about Locke's arguments for equality is that they are all based on the Bible. And Locke does not come up with a single secular argument for equality. So he's not like some big Christian thinkers like Thomas Aquinas, where you can take Thomas Aquinas's work and you can say, well, that idea he's getting from the Bible and that idea he's getting from Aristotle. So you can, if you want, pull his thought apart and just talk about the secular bits. You cannot create a secular argument for equality from Locke. Now, Locke's idea of natural rights is based on the idea that we have duties to God, and that those God override have in political communities. So much of this is coming from Locke's Christian education under John Owen at the University of Oxford. But the key thing that Locke does that makes him a modern thinker as well is that he breaks with the idea that you look out at the world and you work out what is objectively good and what is objectively bad. Locke doesn't think you can do that anymore, so it's up to individuals to decide for themselves what it is good to pursue. So lots of good things, lots of biblical input into Locke's ideas, but this individualism running through it. But the individualism in Locke is nowhere as stark as the individualism in Thomas Paine. If you know anything about the history of ideas, you will know that Thomas Paine was an American revolutionary thinker who wrote a little book called Common Sense. And he and Edmund Burke were both in favor of the American Revolution and fell out massively about the response to the French Revolution. Now, Thomas Paine was very excited about the French Revolution. He was very excited about this idea that you break up all the kind of existing imposed bonds on people. Things like the hierarchy with the aristocracy and then the middle class and lower class, the family, the church, all those sorts of bonds for him ought to go out the window. He wrote to Thomas Jefferson, who became American president in 1789. And Paine says this: imagine 20 people who are strangers to each other meeting in an empty country. Each one would be sovereign in his own natural right. His will would be his law, but his power inadequate to his right. So Paine then describes how these people would do some sort of deal to trade some of their freedoms for protection, but without giving up any of their basic pre-social rights. So this is a highly individualistic conception of how societies get to be made, backed up with his claim in The Rights of Man. Society grants the citizen nothing. Every man is a proprietor in society. Every man is an owner in society and draws on the capital as a matter of right. So Paine's idea is we come into society as individuals and we are entitled as individuals to take whatever we want out of society. Rights come before responsibilities and individuals come before society. Now, I've used the language of rights at the moment as if we all know what I'm talking about. Rights exist on one understanding to enable us to think about wrongs. So if we're able to identify rights, when the rights have been violated, we can see what is wrong. Now, the wrong that is done to people may be different from the degree of guilt that exists in the place of the person who has done the wrong. You know, I could drive my car very badly and crash it and injure somebody only a little, or I could drive my car pretty well but make a mistake and yet leave somebody catastrophically injured. So the guilt that there exists and the wrong that is done can be different from one another. But if we're thinking about rights, and we're talking about human rights in particular, they have to be based on something. And there are really two contenders here. One contender sees rights as possessions. Rights are things that individuals have. The other contender sees rights as relational. So rights describe one aspect of two people's relationship. So to take an example, which a lot of people are experiencing with the coronavirus lockdown being in place, children have the right to be educated by their parents. That is part of what the responsibility of a parent towards a child involved. Now, there are all sorts of other aspects to the relationship between parent and child, and we would be pretty disappointed if we were dealing with a parent who, a bit like the utilitarian James Mill, simply concentrated on educating his child without ever demonstrating any love towards his child. If we take the view that human rights are things which belong to people, the best secular explanation for this is based on capabilities. That human beings have certain things that they are, and certain things that they can do, and certain things that they can achieve, and that rights exist to protect those things. So our capacity for life and health and education, for forming relationships, for pursuing projects, all of those things make us worthy of respect. But there's a problem with the capabilities approach. If you use a capabilities approach, please explain why human rights apply to every human being and only to human beings. So if you give an account of human capabilities in terms of our capacity for reasoning, our capacity for agency, our capacity for choice, our capacity to communicate, well, then that tends to exclude some members of the human species who, perhaps because they have an extremely low intelligence, or because they're in a coma, or because they have dementia, fall outside that definition. Do we then have to say that such people have no rights, strictly speaking? And there are secular thinkers who are prepared to conclude that yes, we ought to be nice to these people, we ought to be compassionate to these people, but they no longer really qualify as fully fledged members of the human race entitled to rights. Now, other people take the view that that is simply because the capabilities bar has been set too high. So what we need to do is lower it a bit. Now, if you lower the capabilities bar a little, then it becomes quite difficult to explain why some animals do not qualify. So in America, they have the Non-Human Rights Project. And the Non-Human Rights Project has sought to argue that chimpanzees and gorillas and orangutans and bonobos display the necessary capabilities to be counted as persons having human rights. Now, if you're looking at my slide, you'll see that those 4 apes are on the left-hand side of the slide, and then there's one little ape sat on the right-hand side of the slide. That little ape is a gibbon, and yeah, the question becomes: well, if great apes qualify, excluding gibbons from rights and from being persons, is that just done on the basis of size? And so where do you stop? Because once I include my gibbon, well, then I might want to include my dog, because frankly, I like my dog more than I like many of the people that I come into contact with. And so the capabilities approach begins to run into difficulties in explaining what it is about human beings that mean that we ought to give them and only them and all of them rights. Now, it's really interesting. The capabilities approach seems to me to account pretty well for something that we are seeing as a trend in the way that human rights is being understood. That what we are seeing is a trend towards human rights applying in practice only for human persons. And that's a loaded term that seems to mean, in the way that its advocates use it, rights only for the choosers. So we get a switch round from abortion being something that the Irish Constitution could say was contrary to the rights of the unborn child, through to this push for abortion as a human right on the basis that the only person, who counts, the only choosing agent, is the mother. And we see that in relation to end-of-life issues as well. This sort of creeping notion of person that disqualifies certain people from dignity and respect in the way that it applies to everybody else. Now, by contrast to that capabilities approach, an approach based on human dignity would say that there are human rights for all human beings because human beings are worth something, and all human beings are worth something. And the best way to account for that is that human beings have special worth because they belong to a species which is made in the image of God. And in fact, Christians would claim that all members of the human species, each and every one of them, has been made in the image of God. And that's a deeply Christian idea, which flows, it seems to me, out of a number of sources, but most definitely and distinctively from Jesus. So when we think about Jesus, Jesus is not born in a palace as if to indicate that only rich people matter. He's born in a stable to show us that poor people, travelers, matter. He becomes a refugee and goes to Egypt to show us that immigrants and refugees matter. He works as a carpenter to show us that manual laborers matter. He lives in a small town and in a village to show us it's not just people living in capital cities that matter. He relates in extraordinary ways for his time with women, including prostitutes and tax collectors he relates to as well. And he suffers a death in the form of crucifixion, which identifies with the criminals, but which also was a form of death that was supposed to be reserved for slaves. And so it's almost as if, God has got a kind of tick list of categories of people that we would want normally to, or have incentives normally to want to exclude or to treat as second class. And Jesus just goes down that list, ticking them off, showing why each and every one of them is important to God. And so that gives Christians a really robust basis for understanding dignity. And frankly, the success of the idea of the basic equality of human beings in Western culture is only explicable on the basis of Jesus. Without Jesus, rational arguments for the equality of human beings wouldn't have cut it. It's the demonstrative impact of Jesus that makes all the difference. Now, I've already given you this idea that this capabilities approach takes us towards rights for choosers. The capabilities approach ties up with this idea of rights as possessions. And so one criticism that is often leveled against human rights is that they come with the baggage, dangerous baggage of possessive individualism, that rights are possessions belonging to individuals. For a little time, I was surprised to think that things could be as stark as that, but you can see it here in its 1959 essay from H.L.A. Hart. Rights are typically conceived of as possessed or owned by or belonging to individuals. These expressions reflect the conception of moral rules as not only prescribing conduct, but as forming a kind of moral property of individuals to which they are as individuals entitled. And Hart claims only when rules are conceived in this way can we speak of rights and wrongs as well as right and wrong actions. So this picture is the picture of rights as things which belong to me. Incredibly kind of stark imagery being used there to think about all of this. I hope you can see that now. That is a t-shirt you can buy if you go into a brothel in Amsterdam, just near the, in the red light district there, just near the Oudekerk, and just captures this idea in a slogan. It's my body, it belongs to me. It's my choice, it's my rights. That's the message that is being given very definitely there. And that is, it seems to me, the dominant and increasingly dominant conception of rights that is kind of taken for granted or just by many people today. Now, when you think about rights in that sort of way, and when you concentrate on rights belonging to individuals, then what you get is a society in which the way to get ahead is to claim, and the way to get what you want is to claim that your rights are being violated or your rights are not being met. And so we get all sorts of claims being made in the name of me first, never mind my obligations to others. Me first, never mind the cost to the community. So what we've got on the right of that screen there is a little picture used to hang inside the French embassy in London. And it says droit à la paresse, which is the right to be lazy. And a sort of approach there from the French civil servants, taking the view that this was sort of their fundamental human rights, and they were allowed a long lunch and not to work all of that hard. And so what you get, if rights are things that belong to individuals, well, then it becomes about getting as much of the pie as you can. So one person asserts their rights, I respond to that by asserting my own rights, and then we get these kind of clashes of rights that are there. And actually this picture of people as individuals has a really odd effect, because when the two individuals end up arguing, well, who gets asked to sort it out? Government gets asked to sort it out. So whereas we thought of rights to start with after the Second World War as a means of holding governments to account and restraining the power of governments, now we find that governments are being given all sorts of opportunities to make decisions affecting individuals and people, because if you've got disagreements going on between individuals, you cut to the chase by going to ask government. And the things that get squeezed there are all the institutions of civil society, the trade unions, the associations, the churches, because that kind of picture of human rights where what matters are individuals and the state has no formal place for any of those other bodies that are there. Now, let me give you, by contrast, a dignity approach to human rights. It runs in a number of stages. Human beings have worth. That is its fundamental premise. I'm talking to you at the moment from my computer. And when I bought my computer, it worked out of the box. I opened it up and I was able to turn it on and do all sorts of things. And it did that because it had software pre-installed on it. So thinking of human beings as having worth is like thinking of rights or worth as pre-installed software. Because human beings have worth, therefore human beings have rights. Now, where does that worth come from? Well, the securest foundation for the idea that human beings have worth is that we were created by and loved by God. And on a Christian understanding of the goodness of the original creation, or when God makes human beings come with an original goodness that is given by God. Now, we can do all sorts of things to diminish our worth, all sorts of evil acts we can do. But a Christian understanding of the nature of evil as parasitic would see the idea that our worth can never be wholly forfeited. Or if it is, it's only forfeited towards God. There are certain ways in which we should never treat one another, even if we are dealing with the terrorist or the child rapist or the multiple murderer. Our worth is to be found ultimately in Jesus Christ, who became a human being, who identified with the poor, the marginalized, and the despised, and who offers God's salvation to every human being. So, two very different pictures. Now, this idea of rights as going with human worth challenges also the idea of rights as possessions. And it thinks instead about rights in terms of an aspect of our relationships. So it's not so much that we have rights in the abstract or against the world at large. It's that our rights are rights with regard to someone. Now, we don't tend to express them like that. We tend to take the example I used before to talk about the right to education, full stop, or to the right to a fair trial, full stop. But actually, these rights describe an aspect of a relationship. When you are in front of a judge, you have a right to a fair trial. The relationship between litigant and judge is one where litigants have certain obligations towards the court, the lawyers have obligations towards the court, and the judge who represents the court has obligations towards the litigants. So rights exist as an aspect of relationships where A stands in a certain relationship to B, parent to child, doctor to patient, judge to litigant. A owes a duty to B and B has a right against A. Another thing I think a dignity approach to rights does is it doesn't start with rights. It starts with responsibilities. This was recognized by American President J.F. Kennedy, who said, "My fellow Americans, ask not what your country can do for you, ask what you can do for your country." And survivor of the Gulag, Alexander Solzhenitsyn, as long ago as 1978, was warning that the defense of the individual rights has reached such extremes as to make society as a whole defenseless. It's time to defend not so much human rights as human obligations. The British philosopher Nora O'Neill says duties come first, and it is citizens who meet their duties who thereby secure one another's rights. And you can see that, it seems to me, quite clearly in the biblical picture where what we have is Moses not giving the Israelites the Declaration of the Rights of the Israelites. Instead, what they get is they get the 10 Commandments. So what the Israelites get is they get a statement of what their duties are towards God and what their duties are towards one another. Now, you can turn these round. So if you think about do not steal. Do not steal is a duty. We can say, well, if I own property, I have a right that my property isn't stolen. Do not murder. I have a right not to be murdered. Do not commit adultery. I have a right that people should leave my wife alone. So you can turn them round. But the Bible puts the duties first, not the rights. And anybody who has lived in a family with or seen small children at work will know why this is. You don't really have to teach a 3-year-old child to say it's not fair. Children are very good at spotting when their rights to fair shares have been violated. You do have to teach a child it's time to get off the tricycle. It's time to share your toys. It comes naturally to us to assert our rights. We need to learn and to be taught about our responsibilities and duties. Now, it's a really interesting question then, whether responsibilities always carry rights with them. Whether you think that depends on whether you think of rights and duties as two sides of the same coin, like heads and tails on a coin. If you do, then you'll think, well, whenever we found a duty, we'll be able to identify a right that corresponds. If you don't, and I don't, I think there are some instances in which we have duties which don't have rights that go with them. And if I'm right about that, that means actually that duties are a more helpful tool for thinking about how we might organize society and how people ought to be treated than rights are. Now, I want now just to spend a few moments thinking about the relationship between rights and religion. And as we've already seen, human rights has got these different stories coming in, these different origins, different and competing and contradictory origins. And those different and contradictory and competing origins give all sorts of different ways in which rights and religion can be related. So Francesca Clark called human rights values for a godless age. That somehow, when we've stopped believing in God, we nonetheless can make some sense of what is good by using human rights to do that. John Gray, who's an atheist philosopher, disagrees with the idea that you can have human rights without some sort of belief underneath them. He looks back at the history and says human rights originated in monotheism, the belief that there's only one God who creates a single moral law for all human beings. Now, I think he's right about that. He, as an atheist, is recognizing that where human rights came from was the belief that there was one God, and because there's one God, there's one moral law that applies to everyone. But then he goes on. There's still a sense in which human rights depend on some sort of religious commitment, because unless they are grounded in something beyond the human world, they can only be a human invention. And for him, where the rubber hits the road on this is at Auschwitz. Yeah, the actions of the Nazis were all approved of by Nazi law. So if you're going to critique them and condemn them, you have to do so on the basis that there's a higher law. And how are you going to find that higher law if you don't have a higher lawgiver? How are you going to use human rights to challenge the power of the state if ultimately human rights only exist because they have been legislated by the state? But we do find people trying to hang on to human rights with what John Gray calls, evangelistic fervor, despite not believing in God. So the human rights get kind of elevated to the status of idol. So Jean-Marc Bertrand talks about them as a religion without God. And the recently deceased British philosopher Roger Scruton says, look at rights. What rights have done to us, thinking about our rights all the time, has killed piety and gratitude. We believe that we owe the world nothing and that the world owes everything to us. Now, what you ought to be hearing there is very clear echoes of Thomas Paine's understanding of rights. And that, he says, is the real meaning of the new secular religion of human rights. And he says, I call it a religion because it seems to occupy the place vacated by faith. So what he's talking about is he's talking about a generation that have abandoned belief in God and substituted a belief in human rights. So instead of locating the ultimate source of our morality and our moral values in God and God's commands, we now locate the source, our ultimate source of our morality, in these ideas of human rights, which somehow just kind of sprung into existence out of nowhere. So there's a problem. There's clearly a connection between human rights and faith, but that connection can be a replacement for faith. But I think what all these philosophers are getting at is the idea that if human rights are to have universal force, they must be objective. The explanation for objectivity is the existence of and nature of God. Angus Ritchie, in his book From Goodness to God, nice easy publication, kind of takes us through that. You know, if you want to believe that things are objective, then actually there are a number of competing explanations for why objectivity might exist. But all of them collapse ultimately, apart from the explanation that objectivity is something guaranteed and based on God. So without God, human rights end up depending on the state, which gives us a problem because they're there in large part to restrain the actions of the state. So what might Christians do then, faced with these kind of competing understandings of human rights? I think one thing to recognize is that this is language that we have to use in order to be understood. A refusal to use the language of rights at all would simply leave our contemporaries baffled. We are having this session moderated by Mike and Jane Norton, and Mike Norton spends his time as a partly retired attorney doing religious liberty cases in the American courts, plugging in there to their First Amendment, which is very definitely picking up on an idea that churches have rights. So rights can be very useful in the courts as a language to argue for justice, as a means for negotiating compromises, enabling people to live with dignity and to worship God freely. But it is for Christians a second language, because it seems to me that love and duty and the pursuit of the good, these are the foundation of a Christian social vision and of a Christian understanding about how we should live and how we should treat one another. So it seems to me we start with those ideas that are integral to our faith, and then we work out from them how we might express some of those in the language of rights. But I do think we always want to be very clear that we're not talking about rights as possessions. We're talking about rights as relational, and we're not just interested in individuals, but we're interested in people embedded in their communities. I think one of the interesting and possibly beneficial effects of this kind of lockdown is that we've been forced to recognize that we don't actually live as individuals, that we do live in households, that we do live within communities and networks and societies. And I'd love to see a kind of change in how we think about ourselves in Europe as a result of all of that. So to conclude, what can we do about human rights? We need to recognize that human rights language is a way of talking about wrongs. We need to recognize that it has all sorts of different origins, which there are competing understandings of it, and be aware, I think, at the moment of the rise of the idea of choice and agency as the foundation of human rights, and the way in which that is stripping away the rights of some of the most vulnerable. We need to recognize the way the language is used in our culture carries with it the dangers of individualism and possessivism, and therefore we need to be alive and working to reform it, putting relationships first, putting responsibilities first, and thinking about what is good for human beings, as well as just what is there in terms of rights.